Hello there. Welcome to another episode of GNLU Orbiter. My name is Swayam Shah and I am joined by my co-host today, Sara Dharwadkar. Today, in collaboration with GNLU Center for Law and Economics, we are doing something that has never been done before in the domain of law, economics, and of course, podcast.
On today's episode, we're going to break down the walls of information asymmetry and reveal the hidden forces of finance, economics, and law. We have with us today Professor George Ringe from University of Hamburg, who is also visiting professor at Oxford University. From algorithmic trading, ESG investing, corporate governance, and decentralized finance, he has done it all and he knows it all. We are very, very grateful to have this opportunity to interact with him today. Hello, sir. How are you doing?
Thank you. I'm very well. How are you?
We're very good too. We're very excited to have this opportunity to interview you. We'd like to ask you, how was your experience at our conference for law and economics?
It's been wonderful. I had a great time here in India. I'm very happy that I came and got to know many new interesting colleagues and meet some students. So it's been a wonderful time here. Thank you.
Thank you, sir. We're very obliged with that. Should we begin with our questions?
Okay.
Sir, so the first question that I have, that law and economics emphasizes incentives as well as efficiency. However, that probably or sometimes is in conflict with the traditional legal based approach of the judicial system. So, what are your views on that?
Yeah. Law and economics is different than traditional law because it doesn't just describe and it just doesn't apply the law, but it makes some prescriptions or some suggestions, one should say, on how the law should be. Right? It makes more normative claims rather than the traditional legal doctrine does. And in a way, I think that's the advantage of the field. So it brings in some normative ideas. It's actually a great tool for policymakers to look to, right? So policymakers get ideas of how the law should be under efficiency considerations. Mind you, they don't have to follow that advice. So I see always law. I talk to lots of policymakers in Europe when they have new projects for regulation. They're always listening, and they don't have to. I mean, that's the thing, right? They can ultimately say, but for these reasons, I think reasons of fairness, judicial protection, whatever, is more important. But it's still important for policymakers to know about the empirical context, what is the effect of legal rules, what might be under economic perspectives be the most efficient solution, right? So I think law and economics is a bit more modest than you put it. It's not a rival, but it's an alternative and informing the way policymakers can think about the law.
So, next question that we have is is based on the Coase theorem, which basically suggests that in the absence of transaction costs, private bargaining yields the most optimal outcome. Now, when we talk about financial markets, it's nearly impossible that there are no transaction costs. So, where does law come in? Where do the legal frameworks ensure efficiency? And how is it possible to frame a law that is effective in addressing these costs?
Great question. So the Coase theorem is like our Bible in law and economics, right? The first rule that we always have to follow. And rather than saying the law doesn't matter, I think the main lesson for policymakers is try to do two things. First of all, define property rights as clearly as you can, because that's the first precondition for the magic of the Coase theorem to work. So first of all, you need to know what you own, what it entitles you to do, where does your property right end, and then based on that clear legal framework, you can start trading. Right? That's when business activity begins, which is beneficial. And the second thing that the law, that policymakers can do, is to try to lower transaction costs where they can, to lower information costs, for example. Right? And here, for example, I have great trust in new technologies. Right? So new technologies bring the world together. Just think of the internet already, which is lowering transaction costs dramatically because you can have access to information around the globe. And now think about the new things like artificial intelligence, blockchain technology. All of this is dramatically helping and overcoming the old style paper information that we used to work on, over the last century or so. So it's on a good way, I think.
Building on that answer, a trend that has been recently observed is that companies often exploit or rather utilize the differences in financial regulations across countries, and the regulators in the countries then face the trouble of the race to the bottom. How should the regulators decide what to do in such a situation?
Yeah, it's true. In financial regulation, that's a big problem because financial institutions can quite easily and quickly move anywhere in the world. Money is easily movable. It's not an asset, it's not a factory that you have to move. It's just money goes like this. And firms are global and they exploit the legal system that fits best to them. In the absence of any world rules, right, that's something we don't really have. We don't have a world government that prescribes us the rules. We need to be very careful about these things, right? And there are some people who argue it's a race to the top rather than to the bottom, right? So they argue it's because countries being in competition with one another can also have beneficial effects. And I think there is some truth in that. So if countries are under pressure to perform good service and provide a good and efficient legal system, then that's a virtue, right? But they should safeguard against the problems, namely of financial stability, for example, or protecting any vulnerable groups, any stakeholders that have been left out. So I think a lot of it comes down to the process of how this arbitrage between different countries is ultimately exercised.
We'd like to talk on a global note once more that we see a change from globalization to a more protectionist outlook of countries recently after the USA incident. So, what are your comments on that? Where's the world going?
Yeah, indeed. We live in a world of deglobalization almost. It's not just decoupling or de-risking, but the entire global world order is put in question at the moment. I can only say, maybe there is an opportunity for countries in the world that still believe in free trade to search for new friends. And the European Union and India, for example, are negotiating a free trade agreement. The European Union is also in talks with Latin America. So, I think this is a fundamental shift to the world economy, absolutely right. Yeah, but new alliances might emerge. And so those parts of the world that still believe in the virtues of these things should go ahead and should be unattacked by these developments.
That's true. Now, I would like to discuss a bit on ESG. Many argue that ESG investing is more or less utilized as a tool for corporate greenwashing. What are your views on that?
I would reframe it a little bit. I would say ESG reporting is not greenwashing, but it's plagued by greenwashing, right? This is how I would put it. So greenwashing is the problem. ESG investing is something that the market is doing, right? So there are investors asking for these products for a particular reason that we can separately discuss if you like. But greenwashing is then the problem that some companies are saying, oh, I'm super environmentally friendly, I'm super green, right? And the answer to that is that this is where regulation has a role to play in making things comparable, in trying to standardize what do we mean with E, what do we mean with S, with G, right? And ideally, then we come back to the global discussion, ideally, of course, on a global level, right? Because investing on capital markets is a global affair. And if every country has its different standard, then we run into the same problem of having a chaos, right? So there are attempts to standardize these things worldwide, but you will understand that this, again, is a very difficult thing to agree on the global scale and plagued by politics and plagued by interest groups, but it's still, I think, the right way forward. Mind you, it is much better to standardize, to make information comparable rather than to regulate these things in substance, right? So the goal of avoiding greenwashing is simply to standardize the information that's been disclosed, and then ultimately the market can still make an informed decision based on the information that's been given to them.
So I think India has a similar reporting mechanism, that is BRSR reports. Yeah. So would you agree that with ESG, instead of being an obstacle to growth, it is rather fostering growth?
Yeah, I think the beauty of the approach is that it ultimately puts the decision into the hands of the investor. Yeah. So it is much preferable over the government going in and directly regulating businesses and telling you, you're not allowed to pollute more than this, or you're not allowed to do this activity, or that is prohibited, this is allowed. That would be the alternative. Right? In comparison, ESG investing may seem burdensome because you need to disclose a lot and information is coming and coming, and the businesses are complaining. But I think it's much preferable than substantial regulation. So ESG disclosure has the advantage of being disclosure, and then ultimately the investors, the market, will decide based on the information that's been given to them, provided that greenwashing is addressed. Mm.
More substantive measures than signaling, as you said, Professor. Right. So, on the same vein, I mean, when we talk about ESG globally, the whole point is that we're moving towards a more resilient structure where climate change is also factored in when we talk about companies and what they're doing. So, what international obligations do you think are placed on corporations and companies to mitigate or address climate change?
That question brings us to the international phenomenon known as climate actions. And the answer to your question is ultimately it depends on the country we're looking at. So there's a very active litigation activity going on in the Netherlands, for example. I don't know whether you have heard of the Shell litigation. So Shell, the big energy company, was sued by environmental interest groups for not, for harming the environment, essentially. So it was just a general public interest groups, Friends of the Earth, suing this oil company in the name of the public and saying, you have an obligation to not harm the general public, right, the environment. And it raises fundamental legal questions, namely, is one interest group entitled to bring litigation on behalf of the general public? Where is the harm? Can you quantify the harm, right? And how much discretion do you leave to corporate management? Right? How strong is the contribution of Shell to the overall problems to the environment? So this decision is very, very controversial. But climate actions like this are now coming up like mushrooms everywhere in the world. And I'm a little skeptical whether this is the adequate way of going about this problem, right? So the alternative would, of course, be to leave it in the hands of democratically elected policymakers, rather than having courts firing small shots at companies. And plus, there is again the problem of having worldwide very different views, and depending on the country you're in, you run into the risk of being held liable. In some countries you don't.
And even the difference in resources, not every company and country can afford to maintain the same level of standards as developed countries do. So that problem also comes.
Right. That's true as well. Yeah.
With the EU imposing sanctions, which I often support. But at the same time, what should be done in certain scenarios? Should the shareholders rather take an activist view, or should they rather promote information asymmetry because they have invested money in the companies, and because of a sanction, the stock prices and everything would plummet down? So, as a shareholder of a company, how should they choose their next action?
So shareholders always have the choice of either exiting, selling. If you are unhappy with the company, that's the easiest choice, right? Because you are not happy with what the management does. You're not happy with how environmentally ambitious they are, for example, then you sell. And that is a positive thing to do, because if lots of people are dissatisfied, the share price will drop, and that's very bad news for the company, right? So that's a market mechanism. Now, the alternative to exit is voice, right? So you can exercise voice, meaning you become engaged, you vote in favor of a particular policy, you support a particular management proposal, or you support something that an activist investor or a hedge fund or whoever does, right? That might be another way of going about it. And I suppose there is no genuine general answer to this question, right? It really depends on the particular preferences of the shareholders, depends on how, the cost-benefit analysis, how strong is my influence in the company. What we see recently is that shareholders build alliances, so they form up teams of different groups because just by themselves they are too small, but they might build coalitions with an activist investor. And together, if you get a pool of investors together, they can implement a meaningful change. That's also a possibility. And now the latest development in this field are institutionalized platforms. You have international platforms of hundreds of investors who build teams together and target particular companies in a particular objective. So this market is fast moving.
So, as you said, professors, economies are in a constant state of flux, and the new thing we all are talking about these days is BlackRock and Vanguard, and they hold massive stakes in these publicly funded companies. Do you believe that there needs to be a limit on their decision making when it comes to corporate governance?
Right. So BlackRock, Vanguard, and you can add State Street, the big three, the so-called big three, are indeed almost owning a share in virtually every firm around the country, probably around the globe. And that has, I would say, positive and negative implications. So on the negative side, this is coming mostly from a competition law or antitrust law perspective. There is evidence that as soon as a universal owner is invested in lots of different firms, in particular in two competitors, the incentive to compete between the two companies is declining. This has been described mostly in the airline industry. So if you are BlackRock and you are invested in airline one and airline two, there is less of an incentive for the two airlines to compete aggressively in prices, for example, because they both are owned by the same. Right? So that may be a problem that speaks against this, and competition lawyers are very upset by this. This is a big topic for them. Now, for our topic here, it might also have positive implications, namely that these universal owners, it's true that they become less interested in the fate of an individual company, but they are interested in adopting policies that benefit the system as a whole. Right? And so, for example, things like climate change, which are systemic issues, right, which are not singularly applicable to one firm, but they may pose a risk for the market as a whole. So universal owners are pushing for policies that benefit the stability of the system as a whole. So in that sense, it's no surprise that these big three are adopting generic policies that seek to further ESG or other goals in light of their universal positions. Right? So light and shadow, and it's something that policymakers definitely should be aware of.
Now I'd like to shift the conversation and talk about the fintech part. In that, if you could briefly explain what is algorithmic trading and what are the legal challenges that come with it.
So it's, I mean, trading on stock markets is happening automatically to a very large extent, has been actually for years now. It's very rare that you walk into a stock exchange and there are physical traders, people from flesh and blood. This is a thing from old movies, but not anymore happening today. I don't know the exact figure, but a vast majority of the trading today in most countries in the world is happening electronically or by algorithms. Now, what you're alluding to is also the phenomenon that most recently now firms are using artificial intelligence to support that trading. And this is where it becomes really interesting, right? Because this is different from just pure electronic trading, where humans are just using technical means to execute their decisions. But what if artificial intelligence is making the decisions? So I have one research project where we explore the potential that you basically just give a pot of money to an algorithm, and the only instruction you give to them is you go and trade algorithm. The only instruction I have for you is increase the returns, right? Make as much money as you can. That's all. And the algorithm goes and tries an error, right? Try error and starts trading. And not surprisingly, maybe after a short time, it finds out the most profitable strategies are the ones basically where it's cheating. So it is engaging in activities and trading activities which are very problematic and which are prohibited for human traders for a good reason. So we call that market abuse or insider trading or these things, right, which are prohibited on capital markets. And it's somehow shocking, right? That research project really was shocking to see that algorithms very quickly learn techniques that are very similar to what is prohibited for humans. So there is a lot to learn also now for lawmakers on how to address these concerns.
That is actually very interesting to see how an artificial intelligence model is, resembling a lot of human behavior in that sense. In the same line, like you said, a lot of your research is based on this AI. AI in banking, you talk about the problem of black boxing of AI in banking. Could you elaborate a little on it? And also, a follow up question is, does it not contribute to information asymmetry?
Okay, so black boxing refers to the problem that an AI takes a decision which later on we don't really fully understand how it was ultimately triggered. Right? So you have to understand that into an AI, there are a million different points of information moved into. And then at the end of the decision-making process, the AI takes the decision. In banking, for example, the bank or the algorithm may either grant you the loan or may refuse to grant you the loan. But we humans, after that, ex post, we don't exactly understand what ultimately was responsible for that, right? So we don't know whether it was that the algorithm took the decision because the client is not creditworthy, or because they don't like the color of their skin, or because of this and that, right? So the risk is that, first of all, we don't know, we cannot complain, right? And we invite discrimination and other harmful practices to move into these important decisions, right? So the black box problem becomes more important the more independent and the more autonomous AI decision making is, right? And in fact, on the previous algorithm trading idea is the same problem, that we don't, and that of course brings about the problem later on that we as market supervisors, it's very difficult for us to prove that this was a harmful activity, that this was a discrimination, or that this was done by intent, the collaboration or the market abuse that was carried on. So that raises a number of accountability issues in the end, I think, to summarize.
At the end of the day, I feel like it makes our job as lawyers difficult because
Yes.
our whole point is
Yes.
to prove
Yes.
evidence, does not.
Yes, it does.
So, in this case, would you believe that the market forces will factor this in and lead to a better optimum outcome, or should the government put his hand inside and solve it?
Oh, the government definitely needs to do something about it, absolutely, because otherwise it will be, as you say, it will be impossible for lawyers to prove anything, to bring any accountability claim, for example, or for supervisors to take any action against it. So as soon as you move something out of the hands of the humans, it cannot be controlled, and that's a problem. So regulators are, of course, discussing what to do about it. There's no perfect response yet, but you could imagine an ex-ante control, for example, before an algorithm is allowed to be on the market. It needs to be screened and checked, for example. That sounds good at first, but the problem is algorithms usually are self-learning, right? So you don't know at the first beginning how, in what direction the algorithm will move and develop later on. So you probably need a constant supervision mechanism, a screening, like your car. I suppose it's probably the same in India. In my country, you need to bring your car once a year or once every 2 years, I think, to be checked, right? Whether it's still safe for road safety. And in a way, it could be similar for an AI algorithm, and maybe on a more frequent basis. I think another response, more generally speaking, is that supervisors, market supervisors, banking supervisors also need to equip themselves with more technology themselves, right? Because as the business is digitalizing itself, supervisors also need to use those technologies in order to detect these problems. Right? So in a way, supervising AI through AI is probably the only real solution. In a scenario in the future, it might be even that they are supervising them in real time, so that information is constantly being reported to a supervisor and examined in real time. And only when there is a red light going on somewhere, then human supervisors might even be looking at it.
That makes sense, sir. I believe that there's this saying in economics that when policy blurs the lines, markets pay the price. So you summarized that beautifully in your answer, sir.
Couldn't have put it better. Yeah.
Now, do you believe that blockchain technology as well as decentralized finance can be regulated within the existing legal framework, or should the entire framework be amended?
Oh, that's another big question. So blockchain technology is has been praised as the solution to many things, and has also been hailed as a law-free environment in a way, because it is completely free from any regulatory oversight, and because it provides the solution itself. It's very difficult to deceive anybody because things are stored in a decentralized way in a long chain of computers. So it's very difficult to deceive anybody. Right? And information costs have been dramatically reduced. To come back to the Coase theorem, you can be sure that the information is correct, so you don't need to investigate as much. So many great big big advantages, I wanted to say, come along with it. And there were great hopes in this new world order that's been created by the blockchain technology. Sadly, though, we are recognizing that new problems emerge and new externalities are being created, not least the environmental externality of huge computational power that's been needed to operate the blockchain. But also, new intermediaries that pursue their own agenda. The coders, right? So the ones who are coding the blockchain, they have their own agenda. They are, basically also creating agency costs. The people who are forking, right, who are manipulating the blockchain. There's lots of fraud as well, because lots of people have invested in the blockchain and then somebody is running away with the money. So it is, I would say, old wine in new bottles, right? It is bringing in new problems. It is not the all-in-one solution that once everybody hoped for.
So, follow up to that, in economics, there's this concept of efficient crime, wherein, so do we as a system have the ability to manage the social cost that the externalities bring? Is it worth regulating it? Is the social cost greater than the social advantages that come with blockchain technology?
No easy answer to that. There is definitely, as I was trying to say, a new social cost. It's different from the one. It is dramatically reducing part of the cost of business transactions, right? But it's creating new costs, and we definitely need to. It's not a law-free technology. That's for sure. So we need to find new attempts of regulating it, and because it's a global technology, we run into the same problem again, that we need to define a global framework for it, ideally.
That's an interesting approach and answer. I'd like to now further shift to a different topic, that is the topic of banking. The question, firstly, I'd like to understand the term. What is bail-in?
What is bail-in? Bail-in is an attempt to do the opposite from bail-out. Bail-out was, of course, the trend that we saw after the last big banking crisis, 2008. Bail-out was the common thing that governments did at the time, namely to have huge rescue operations for large international banks. So they were all being rescued by governments, essentially using taxpayer money, because it was feared that we need to keep them alive. Otherwise, the cost of failure will be much higher, right? And bail-out, of course, has a number of disadvantages. Namely, it creates lots of moral hazard. Moral hazard, as you probably know, is the problem that if I know as a bank that the government will rescue me, because I'm so big, I'm too big to fail. That's the slogan. I'm too big to fail. The government will come to my rescue. That invites irresponsible behavior. So you have an incentive to do very risky transactions because the government will always come to my rescue. So long story short, this is why everybody is recognizing that bailouts are not great. They're also politically popular because the voters don't like them, throw lots of money at the big banks. So ever since the financial crisis, we've been trying to develop, and there have finally come to the point, alternatives to bailout. And one of them is bail-in. That is to say, rather than rescuing the banks with public money, with taxpayer money, we try to allocate the losses of the banks to the investors of banks, namely to shareholders and to bondholders of banks, so that ultimately banks are treated like any other business. If you think, for example, of, let's say, a big normal company is in trouble, a big car maker is almost bankrupt, and the company is going bust, then who loses money? Well, the investors of the company. It's a normal thing in a market. It's not nice, but this happens in an economy. It's not being rescued by anybody. Banks have been rescued, and it's somehow unnormal. So bail-in is trying to treat banks like any other normal company. Investing in a bank should be risky. And if the bank is entering into too much risk and fails, then you as an investor, you have to bear the losses. So this is ultimately what bail-in is trying to do.
So from what I gather from your answer and from what I read from your research paper, basically bail-in is a mechanism where you are recapitalizing instead of liquidating.
Yes.
But the problem with the Indian scenario is that the backbone of the Indian banking economy is based on public sector banks with extremely heavy involvement of the government where it is saving it out. How is this mechanism applicable in a country like India?
Yeah, not so easy. I admit that the concept is mostly meant for privately owned banks, because you have private shareholders, private bondholders who invest and who have to fear the consequences of their decision making. And for them, that makes a lot of sense. In the public sector sphere, things are different. You can try to impose the same thing, but the consequences will not be as dramatic. Governments cannot run out of money. Governments can always print money. Governments can always increase taxes. Governments simply are not like any other normal shareholder. So I fear that the disciplinary effect of bail-in is not the same in that setting. The only thought I had was that it should work then through the democratic process. If state-owned banks are not performing and constantly failing and have to be rescued, and the government is increasing the taxes because it needs to rescue banks, then that should lead to democratic accountability in the sense that the voters punish the people, politicians who take those decisions, right? So as soon as you move into state-owned banks, it becomes more of a constitutional or public law problem rather than a business law problem.
That is very interesting how the perspective in the private sector is very different from the perspective in the public sector, but it's the same thing with regards to striking a balance, with regards to who has the power and who has the bargain and who has to pay the price in the end. So moving on to the lighter side of the questions, what do you think is the one emerging technology in the field of law, economics and finance that will define the next decade other than AI?
Other than AI, okay, that limits the choices. I don't have a crystal ball, but I assume that quantum computing is up and coming, right? So this is the big new thing, which will, of course, dramatically change the world in the next step. So if I was to bet, then this would be something to look into. It changes the computational power, of course, dramatically, and many of the things that we find it impossible to quantify and to calculate today will be calculated within seconds, milliseconds in the future. So the next technological breakthrough is just a corner away.
So when it comes to innovation, a lot of companies are spending years and a lot of amount of money to get the next breakthrough. Now, once they do reach that level, do they have a moral obligation that how they should treat, or should they rather resort to presenting asymmetric information because that is just channelizing their hard work into profit?
I'd say there needs to be a certain asymmetric information in the market. If everybody had access to the same information, then basically there wouldn't really be any trade. Trade benefits from the point that I have done more research, I know more than you do, for example, and that is why I buy your piece of land, for example, because I have another idea of what I can do with it, for example. I know that there is, precious raw materials in the ground, which you don't know. Right? If there was a moral duty to disclose everything, then there wouldn't be any trade between us. So because I would have to knock on your door and tell you, hey, by the way, in your ground there is raw materials, and this is why I would like to buy it. Then you would drive up the price so that we wouldn't agree on anything, right? So the legal system, the economic framework needs to facilitate informational advantage, needs to honor that people do investigation, do research, right? And then that needs to be rewarded. On the other hand, there are certain situations when you buy a car, for example, as maybe we discussed yesterday in class. Well, it's vital information for the buyer to have certain information to make an informed decision and to find out whether the car had an accident before or not, for example. And so this type of productive information is something that definitely has to be disclosed. Otherwise, there will be no efficient decision making. So it's a very fine balance to strike between these two scenarios.
I believe that regulation basically needs to strike this fine balance between the two. And for example, the Competition Commission of India, the motto is not to protect the competitors but to protect the competition. So I believe if that's what we look into, then we'll be able to balance the interests of both parties and competition will thrive within the legal framework. Moving on to a more research oriented question, because you have a lot of extensive research that you have done. What would you suggest are a few topics that students of law and economics could research on in the present day scenario?
I think we've covered many of them. Digital topics are, of course, everywhere these days. It's not just in my field, in capital markets, in banking, in corporate governance, but also many other markets are becoming more digital, raising competition concerns, for example. Competition law has a certain renaissance in recent years because many new big dominant players like the big American tech companies are raising new fundamental market structure problems. So these are very exciting questions, I think. At the other end of the spectrum, our planet and sustainability and environmental concerns remain a fundamental issue. So raising many law and economic questions of externalities to the world. And if I want to add one third dimension, maybe the combination between the two. Right? So that maybe, in answering your question, is a very future-oriented perspective. How can we combine these two mega trends, right? Digitalization on the one hand, sustainability on the other. Can there be any mutual beneficial effects between the two? Can we, for example, use technological tools in order to promote sustainability? Or the other way around, can we make technological tools like blockchain, for example, more sustainable in a particular way, reducing the energy consumption in any way? So these are mutual effects that are known as a twin transformation, which is, I think, a very important thinking in policymaking.
Isn't it very much in line with the Caldor-Hicks principle of taking from one and giving to other, but at the same time keeping it equal for society?
I'd go even further, right? It's a win-win-win situation in three dimensions, right? It's beneficial for both trends, but also increasing the pie for all of us.
To explore on that topic further, are there any online research journals that you would suggest us to read or publish in, or any online courses that we could take or attend?
Plenty of them, of course, depending on your preferences. I myself edit a journal named the Journal of Financial Regulation, which is tackling some of these issues, more, of course, on the financial regulation side. There are, of course, many online journals in the law and technology sphere. There are blogs. There are many excellent law blogs. I can recommend the Oxford Business Law blog in particular. but many other excellent resources. And teaching is moved to MOOCs, to massive open online courses. So plenty of resources. If you want to find out more about any of these topics, I think you should start with a Google search and you will immediately come to plenty of good resources out there.
If you had one book to recommend to all the students, which book would that be?
Yeah, so on corporate governance, the leading book is still The Anatomy of Corporate Law, a heavily law and economics influenced account, a comparative account of the major systems around the world in corporate governance, and it's providing an excellent framework for analyzing corporate governance and corporate law. On the banking / financial regulation side, I would recommend The Principles of Financial Regulation, also a wonderful and global analysis of financial markets and their regulatory questions.
With that, we have come to the end of the podcast, and I'd like to ask one last question. What advice would you like to give to law students across India in the field of law and economics?
Remain curious, think big, be ambitious, and there are so many exciting questions that lie ahead. So I'm very envious of your generation that will hopefully find answers to all of these questions. So, for example, is our legal system really able to tackle all these big global questions? I mean, we sort of touched on it today, but there's also a bit of a territorial problem here, because we are facing global problems like sustainability, like digitalization, AI, and yet legal systems are still providing national solutions. To what extent can you really enforce this to a global company? How can Indian legal standards be imposed on and litigated in a court here in India when the defendant is located in the Cayman Islands, for example? Maybe you can still litigate it, but how can you enforce it? Yeah. Second problem, how fast is the law? Question mark. I mean, asking that question is already denying it, right? Because it's not very fast, and this world is moving so fast. Legislation and courts are basically a thing of the 19th century and are very, very slow in adjusting to change. Right? It takes years to litigate until you get to the highest level, and then by then the world has already dramatically changed. In AI, for example, the world is moving at lightning speed, and we are still discussing. I mean, the European Union has now adopted an AI regulation recently, which is already outdated. So they need to constantly update it in order to keep pace with the developments. So what I'm trying to say is, when you ask me for advice what to do, think big, right? Maybe we need to constantly change the legal system as such. Maybe the tools that we as lawyers have and that we are familiar with are not really cut out anymore for the world that we are facing with today. Maybe the law itself needs to change, needs to become more technological itself. I don't know, I'm just asking the questions here. But you asked me for the questions, right, to explore.
We are extremely, extremely grateful to have you today with us. And we'd like to tell our viewers that we only give him a notice of 1 day, and yet you agreed in the most efficient manner possible, and we're extremely grateful for that, and we'd love to have you one more time in future when you again revisit India and GNLU.
Thank you for this very nice conversation, and I very much enjoyed being on this.